In older records many people were turned away at the border, told to try again later. There were no ticket numbers, appointments, or guarantees of when they would be processed. Repeated "come back again" kept people in Mexico. The question is, was this merely waiting in line, or had the legal process never even begun? Sometimes nothing but a border line on the ground separates a person from U.S. territory. In law, however, that last step is not symbolic. It decides not whether asylum will ultimately be granted, but whether the gateways to inspection and applying for asylum under 2 federal statutes have opened. 6-3. The answer is no. On June 25, 2026, the Supreme Court stated, individuals still standing in Mexico are merely attempting to arrive in the United States. Only by crossing the border do they count as arrived in the United States under these 2 statutes. This is not a ruling that shuts down all U.S. asylum. The question before the court was much narrower. Can a person at an official port of entry, already facing U.S. officials, but not yet having stepped onto U.S. territory, be legally considered arrived in the United States? The first gate is 8 U.S.C. 58. It doesn't first ask whether a person can win, but rather who can apply. A person who is physically present in the United States, or a person who arrives in the United States, may apply for asylum under this section, and the applicable procedures of sectors 1-25. The statute begins with the first category. The applicant is already inside the United States. The English phrase is physically present in the United States. Someone may have entered long ago, and applied for asylum only later, after conditions in their home country changed. This category does not depend on whether that person is now standing at a port of entry. The second category is arrives in the United States. The dispute lies here. Is it meant to separately cover individuals standing outside the country who have already reached a port of entry, or does it only describe individuals who have just entered the U.S. and immediately entered the inspection process? The 2 gates in the same sentence appear to almost overlap. The second gate is lecture 1225. It stipulates that a person not admitted but already in the United States, or a person who arrives in the United States, is considered an applicant for admission. This status is not final admission, but the starting point for subsequent inspection. After becoming an applicant for admission, 1225 requires immigration officers to inspect all persons applying for admission, or transit. Thus, when arrival occurs directly determines whether the inspection duty has been triggered when an officer faces an individual outside the line. In inspections where expedited removal applies, if an individual expresses an intent to apply for asylum, or states a fear of persecution, the statute requires referral to an asylum officer for a credible fear interview. This is still only screening, not asylum approval. So this lawsuit is not about who should receive asylum, but who has the right to first enter this statutory process. Entry, screening, and final adjudication are 3 different gates. Conflating them would exaggerate the ruling into completely different news. The Ninth Circuit Court of Appeals recorded that before 2016, individuals seeking asylum at ports of entry typically crossed to the U.S., sighed first, then waited in line for inspection. In other words, the line might be long, but the procedural entry point and the geographical border were on the same side. In 2016, Customs and Border Protection began limiting flows due to processing capacity and facility security. In November, the Department of Homeland Security approved metering. When a port of entry deemed its capacity full, it could limit the number of individuals entering and being inspected that day. What truly changed the case was the control point being pushed to the actual borderline. A 2018 guidance allowed officials to set up access control as close to the international border as possible, and once a traveler had entered the U.S., processing had to be completed. People began to accumulate outside the line. Mexican officials and non-profit organizations created waiting lists to maintain order. U.S. border personnel sometimes coordinated informally, but kept no list of their own and could not give formal appointments once port capacity had been reached. The Ninth Circuit's factual background states that waiting periods could extend from days to weeks, or even months, and real risks accumulated over time. Note, this is the factual background recorded by the lower court, not a legal conclusion found by the Supreme Court majority opinion. Otro Lado and 13 asylum seekers sued in 2017. Their core request was not for the court to grant asylum directly. It was a ruling that the government could not keep people outside the line, and thereby refused to start the inspection and application process at all. DHS rescinded the old metering guidance on November 1, 2021, but rescinding the policy did not automatically end the lawsuit. The lower court later entered a declaratory judgment, holding that it was unlawful to deny inspection or asylum processing to class members who were arriving. In 2025, a divided Ninth Circuit affirmed key parts. It held that as long as a person is at the border, facing U.S. officials and seeking entry, they can be considered to have arrived in the United States regardless of which side of the border their feet are on. Therefore, inspection is not an option that can be indefinitely postponed. Why did the government keep appealing after the policy was rescinded? Because the lower court's declaratory judgment still constrained what the government could do. Within the Ninth Circuit, at the Supreme Court, the government said it wanted to preserve the legal option of reinstating metering if border conditions again made it necessary. The Ninth Circuit's textual reasoning can be condensed into a dual-gear mechanism. Congress wrote both physically present in the United States and arrives in the United States, so these two sets of words should each bear distinct meanings. Otherwise, arrives in the United States would be almost entirely swallowed by physically present in the United States. It also read the repeated word shall in sequence 1 through 25 as a mandatory chain. Once someone is an applicant for admission, officers shall inspect that person. Once the person expresses an intent to seek asylum or a fear of persecution, the process shall continue to referral rather than leaving the port to decide indefinitely whether the process ever begins. This also explains the distinction between delay and withholding processing. In the Ninth Circuit's analysis, an orderly delay must at least allow tracking of who is waiting. In the old records, officers did not issue ticket numbers, make appointments, or maintain their own lists. The court therefore concluded that these individuals were not entered into a processable queue. The Supreme Court took up the case in November 2025 and heard oral argument on March 24, 2026. From the 2016 policy to the 2026 ruling, a decade of policy and litigation was compressed into one question. Can a person standing in Mexico already have arrived in the United States? At the beginning of oral argument, the government stated its position directly. You cannot arrive in the United States while you are still standing in Mexico. The finished film keeps a short excerpt from the Supreme Court's official recording, so the dispute first appears in the speaker's own voice.
That theory is wrong for the simple reason that it defies the statutory text. You can't arrive in the United States while you're still standing in Mexico.
The majority opinion first used everyday language. A guest walking to the door, knocking, or even being locked out by the homeowner cannot be said to have arrived inside the house. Being blocked explains why entry was not made, but it does not change outside the door to inside the door. The majority also used a football example. A running back stopped at the 1-yard line has not crossed into the end zone, so 6 points do not go on the scoreboard. Being very close to the destination is not the same as having arrived. There's also a letter. It is only a few inches from the mailbox. The letter is still in the mail carrier's hand, so it has not yet arrived in the mailbox. All three examples reinforce the same point. The majority opinion interprets the English preposition here as within the boundary, not near the threshold. The majority then look to the Immigration and Nationality Act as a whole. When other provisions are meant to cover an unsuccessful effort to enter, they expressly say enters or attempts to enter. Sections 1158 and 1225, by contrast, say only arrives in. The court treated that omission as an intentional distinction made by Congress. Elsewhere in the same Immigration and Nationality Act, it explicitly states arriving near a land border, meaning arriving in the vicinity of a land border. The majority opinion stated that Congress knows how to define the scope to include the area around the border, but in these two statutory provisions it chose not near nor at, but in. More critically, the text changed. The old law used to read physically present in the United States, or at a land border or port of entry. In 1996, Congress changed the latter half to arrives in the United States, while also overhauling the expedited removal process. The majority opinion states that when words change, one should not assume the scope remains entirely unchanged. The Ninth Circuit and the applicants seized on a dilemma. If someone who arrives in the United States must already be physically present in the U.S., then they are, by definition, also physically present in the United States. In that case, why would Section 1158 list both phrases in parallel? The majority opinion conceded that this argument has some force, but stated that avoiding redundancy is not an ironclad rule. The two categories are also not entirely identical. Some enter the asylum process upon arrival. Others apply as physically present in the United States much later after entering with a visa due to changed circumstances. The majority opinion's primary explanation is that in 1996 Congress simultaneously created expedited removal and incorporated arrives into sections 1158 and 1225. The repetition of this phrase was to connect the same arrival event to inspection, expedited removal, and asylum screening concurrently. Unless Congress states it very clearly, U.S. law is generally not understood to extend extraterritorially. This is called the presumption against extraterritoriality. The majority opinion stated that these two statutes do not clearly require officers to inspect or receive applications on the Mexican side, thus connecting the obligation to the U.S. side. The applicants also invoked the principle of non-refoulement from the Refugee Convention. The majority opinion, relying on a 1993 Supreme Court decision, held that the non-refoulement obligation under Article 33 of the Refugee Convention does not apply to individuals located outside the United States. This treaty obligation, therefore, did not push the statutory gateway in this case to the Mexican side. Combining those three layers of reasoning, the majority drew the threshold at the international border. Standing in Mexico and attempting to enter does not, by itself, create a right to apply under these two provisions, or a corresponding duty to inspect. The Supreme Court reversed the Ninth Circuit's judgment and sent the case back. The majority opinion also described the old metering as delayed entry, not a permanent blockade. As for what would happen if a future government prevented everyone from approaching the application entry point, it stated that this was a hypothetical policy, not part of the record actually litigated in this case. Justice Sotomayor, writing for the three dissenters, drew the opposite conclusion from the same sentence. Because Congress placed physically present in the United States beside arrives in the United States, she argued. The second phrase should cover at least some people who are not yet physically inside the country. In the dissent's view, a formal port of entry is the legally designated place of presentation. When a person arrives at the entrance and indicates to U.S. officials that they seek entry in asylum, it cannot be said that arrival never occurred simply because an officer standing inside the line blocked them. She also rejected the extraterritoriality argument. The dissent emphasized that the relevant conduct occurs on the U.S. side. Officers standing inside the United States decide whether to block, inspect, and refer the person. Requiring those officers to comply with domestic legal duties is not the same as making U.S. law govern Mexico. The dissent drew attention back to earlier inspection regimes. It pointed out that the 1917 Immigration Act already required persons arriving at a U.S. port of entry to be inspected. For Sotomayor, the port of entry has long been the legal threshold where individuals present themselves to the government and officials determine the next. The 1980 Refugee Act was even more direct: persons physically present in the United States, or at a land border or port of entry, may apply for asylum. This old text explicitly listed within the U.S. and at the border in parallel, serving as the historical starting point for the dissent's understanding of later phrasing. Both sides acknowledged that in 1996 Congress changed the old phrase to arrives in the United States. The disagreement was over what the rewrite meant. The majority opinion stated that a change in wording should have a substantive effect. The dissent, however, cited committee reports, arguing that Congress still intended to cover individuals who come to the U.S. border. The dissent also read the statute's repeated use of shall as a chain of safeguards Congress put in place. Officers must inspect. If a person expresses an intent to seek asylum or a fear of persecution, officers must refer that person to an asylum officer who then conducts a credible fear interview. If the first link is blocked outside the line, none of the later safeguards can begin. The dissent also brought the 1939 voyage of the St. Louis into the opinion. The ship carried 937 passengers, nearly all Jewish refugees. Cuba would not let them disembark, and neither the United States nor Canada admitted them. Sotomayor used that history to explain her reading of the refugee protection system that followed. It is the dissent's historical argument, not a reason adopted by the majority. The dissent's sharpest point about consequences is that the statutory duty turns on the exact position of a person's foot. Those who follow instructions and stop outside the line have no access to the process, while those who manage to cross the border may trigger it. The majority responded that unlawful entry carries criminal and immigration consequences, and that concerns about policy incentives cannot override what it viewed as the statute's most natural reading. Justice Jackson wrote a separate dissent and began by asking why the court should decide the issue. Now, the old policy was rescinded in 2021. The government had expressed only a desire to preserve the option for future use, with no new record of concrete operations. In her view, the court should not issue an advisory opinion about an abstract policy. Jackson specifically pointed out that the record contains no current policy and lacks key facts, such as actual processing speed. In her view, the court could only guess how a future policy would map onto analogies about a house guest, a football field, and a mailbox. The majority responded that the lower court's declaratory judgment still restricted government's use of metering within the Ninth Circuit, and the government said it might resume metering if conditions required it, because a Supreme Court decision could lift that constraint. The dispute remained live. Justice Thomas fully joined the majority opinion, but wrote a separate concurrence, questioning the lower court's use of declaratory relief to achieve class-wide effects. The 6-3 statutory conclusion does not rely on this additional reason. Put the scope in one sentence. A person still on the Mexican side of the U.S.-Mexico border, who has not crossed the line, cannot rely on the two provisions interpreted in this case to demand inspection or access to the asylum application process merely because they reached a port of entry and faced U.S. officials. It did not delete, rewrite, or cancel the independent statutory category of physically present in the United States. The Supreme Court interpreted the geographical threshold of arrives in the United States. For individuals already located within the United States, this case did not close the door of physically present in the United States. Nor did the decision determine whether asylum should be granted or denied in cases handled by U.S. Citizenship and Immigration Services, immigration courts, the Board of Immigration Appeals, or federal courts. Each case still has its own facts, eligibility requirements, evidence, and procedural history. You cannot infer the outcome of an individual case directly from this borderline. The reverse is also true. Crossing a geographical border only answers whether a person has entered the geographical space of the United States. It does not equate to lawful admission after inspection. Arrives, applicant for admission, and admitted are different legal junctures. Even if proceedings continue expressing fear, undergoing a credible fear interview, receiving further review, and ultimately winning asylum, are still different thresholds. The Supreme Court only drew the first entry point behind the line. It did not automatically open the subsequent doors for anyone. The judgment did not issue new daily quotas, appointment systems, or port of entry operational manuals. It overturned the lower court's legal interpretation, leaving more room for future policy. Whether and how the government will ultimately use it still depends on official documents, genuinely issued and taking effect after. In the future, when you see a piece of asylum news, you can first ask 3 questions. Does it change the entry point into the legal process, a specific step within the process, or the final outcome? If these 3 layers are not separated, the same headline restricting asylum might be talking about completely different things. Entry is not the outcome. A line determines when one steps into these 2 statutory provisions. It does not complete the rest of the journey for anyone. This film, as of July 22, 2026, provides only public legal information. Official judgments, statutes, and oral arguments are in the description. Track U.S.CIS trends, judge grant rates, court jurisdictions, and anonymous case timelines with AsylumTracker.